the third time we are meeting for the Junior Faculty Forum for Indian law teachers. And as it happens, today is Teachers' Day, the 5th of September. So a big thank you to all our teachers around, who've sort of trained us all our lives. And we all know how much influence and impact good teachers can have on our lives. So it's a good day to host this workshop. I should start by first welcoming our author in the hot seat, warm seat, because we don't do hot seats. We don't put pressure, and we're kind people. So we have our author today with us, Ms. Nabeela Siddiqui. She is a research cum teaching assistant at Dharmashastra National University in Jabalpur. And we have two discussants today. We have Professor Farrah Ahmed, who is a colleague of mine from Melbourne Law School, and Ms. Radhika Agarwal, who is a doctoral student at Melbourne Law School. So they will both be commenting on Nabeela's paper. Now, before I pass on the speaker's podium to them, just a couple of introductory comments. So we're going to follow the same format that we have been following in the JFF, which is that the author will not make any presentation. The paper is assumed to be read. And we are assuming that all of you have already seen this paper. You might have noticed that this is a different type of paper. It's a different stage in the writing process than the first two papers that briefly there, but hopefully you can hear me now. So, you might have noticed that this is a different paper in style and where it is in the writing stage compared to the previous papers. This is a very early stage draft. Nabeela has clearly just started thinking about the topic and has written sort of her initial thoughts on the paper. And we've chosen this paper to workshop today because we want to first put out the idea that workshopping a paper is useful at almost every stage in writing. It's very useful to workshop it at the very initial stage. And once you hear the comments from Farrah and Radhika, you will see how early stage workshops can really save you a lot of pain later when you're developing a paper. Finding out the possibilities, honing and fine-tuning a paper at an earlier stage is useful. It just makes a better paper. You can also, of course, the previous two papers were relatively finished. Mohsen's paper was at a really advanced stage. Surendra's paper was sort of an intermediate paper. So we've sort of seen three different papers now at three different stages of development. And hopefully you after this workshop, you can see how workshopping can help a paper at each. So that's the first thing to notice, that we're doing a different type of exercise here in helping the author, which is it's not a final product. This is in some ways thinking with the author what the product could be like. The second thing to notice, so far we've been workshopping to think about how to write, but there's also a skill involved in how to be a good discussant, how to be a good reviewer, and how to be a good author whose paper is being workshopped. And there's some of these skills that you will see on display here today, but I want to highlight a couple of them, especially those that are perhaps not particularly visible. So one of the things that I know Farrah and Radhika have done already in advance is they've shared their written comments that they're going to present today with the author in advance. That's a very good practice in general to adopt. It just, we've talked about why the goal is not to surprise the author or to show how clever you are. The goal is to help the author make the paper as good as it can be. And if you give the author some time to think about the comments you're going to make, to help them reflect upon it better, that's just good academic practice. And I'm very grateful to Farrah and Radhika for sharing their comments in advance with the author. And we've always talked about the importance of kindness when being a reviewer, and you will see two extremely kind reviewers speaking today. The last thing I want to mention, I'm sure Nabeela will bear this in mind, is that remember, if you're the author whose paper is being workshopped, that they're doing you a great service. There is very little, they're not being paid for this, and they could easily just say no. Right? There's no reason why they should do this except for generosity. They're being generous with their time, they're being generous with their intellect. So there is very little point as an author in fighting what they are saying. If you disagree for the sake of intellectual advancement of ideas rather than being defensive about this is not an attack on you, this is an intellectual engagement with your ideas. And the second thing, sometimes workshops go wrong because authors end up taking too long in defending their ideas and explaining them. And that's just hurting your own cause. As an author, it's in your interest to give others as much time as possible to speak on your paper. You're not going to get this opportunity very often. So just take the time to hear what others have to say. Interact, right? I'm not saying don't say anything at all. Interact, disagree when you can, but try to be brief because you want to maximize the workshopping time by listening, by absorbing the comments rather than what you have to say will come out in the paper, right? So those are my opening comments, but with that, I will hand over to Farrah first, who will speak to us on Nabeela's paper on the essential practices test. And I believe that the way Farrah and Radhika have broadly divided their comments, as Farrah is going to do more big picture, general commenting on what this paper could become, and help Nabeela with exploring the possibilities, and Radhika will give more sort of focused and precise comments on particular ideas in the paper. But anyway, with that introduction, I hand over the floor to Farrah.
Thanks so much, Tarun, and thank you to all the organizers for inviting me to be a part of this excellent initiative. It's just really difficult to overemphasize the importance of JFF as a forum, and I really congratulate all of you on the success that it's already had. But the deepest thanks, I think, are due to our author, Nabeela Siddiqui, for sharing our work with us. As we've heard this week, the forum is focusing on the early stages of a research project. And Nabeela has given us a draft with lots of rich material and a great deal of potential. Given that we're talking about the early stages of a research project, my comments, as Tarun suggested, are going to focus on what all of us as scholars are typically doing in those first initial stages of a research project. So I'm going to respond to Nabeela's paper in rather general terms, because I think her paper gives us a very helpful entry point to thinking about how we as scholars can best articulate and refine our research topic, as well as our research question and our tentative thesis. So when I look at Nabeela's research topic, I'm struck by how important and ambitious it is. The Supreme Court's essential practice test is a profoundly important aspect of religious freedom jurisprudence. So the first thing to say is to congratulate Nabeela on honing in on a topic which is both significant and very interesting. That's not always easy. So that's a first step really well done, I think. Within this topic, within this really interesting and significant topic, a scholar could choose a broader or a narrower research question. That is, the question that a scholar is attempting to answer in the paper could be larger or could be smaller. Now, in my reading of this paper, Nabeela has chosen a very broad research question. And I'm going to try to articulate what I take her research question to be. I think it's something like, is the essential practice test justified? Or it's something like, is the essential practice test a good test for the Supreme Court to use in religious freedom cases? Now, that is what I took the research question to be, but Nabeela, please correct me if I'm wrong about that. Now, it's certainly a strength of Nabeela's chosen topic and question that it is important and is interesting, as I said. But its importance and its interestingness, if that's a word, comes with its own challenges. Because the essential practice test is so interesting that there is a large and developed literature and case law on it. So someone working on this topic has to first grapple with this vast literature, this vast case law, and then find something to say that is a new contribution to the literature. As a scholar who is facing this mountain of material that other fantastic scholars have created, a really natural question to ask is, well, how do I go about contributing to this literature? How do I go about seeing something that is new, that is original, that is insightful? And here is where I think it is very useful to articulate your thesis as clearly as possible. That is, you want to articulate as clearly as possible the proposition that you want to prove or disprove. If you look at Nabeela's paper, she points to her thesis at a number of points. So she says in the abstract, and I'm quoting, the test, that is the essential practice test, has served to limit the scope of legal protection under the Constitution and give regard to the interventionist tendencies of the state. And then in the introduction, she says, and I'm quoting again, the paper seeks to argue that the ERP test is not only ambiguous both in its ambit and application, but is problematic to legal scholarships. And then in the conclusion, she says, it is time to do away with the essential practice test. These are good examples from the paper of how to keep reminding your reader of what your thesis is, because you always want to keep drawing the paper back to your thesis. I think that there's some good examples of that in this paper. Now, I want to suggest to Nabeela that for this project, it's really important to further clarify, specify, and fine-tune your overall thesis. The way you state your thesis, it's clear that you are against the essential practice test. And it's clear that you think that it's problematic in some way. But I think you want to specify further why precisely and in what way precisely the test is problematic. What is your specific particular concern that you want to bring to the attention of readers? Radhika, in her comments, she's going to suggest some ways in which the test might be problematic, so I won't say more about that. But I would suggest writing your thesis down in something like the form, the essential practice test is problematic because blank, right? And then fill in the blank as specifically as possible. And then once you are clear about your specific concern and the specific thesis you want to prove, I think it will be much easier to know which arguments you need to make to prove your thesis. One way to make your thesis clearer and more specific is to do a deep dive in the literature on the same research question. As I said before, there's a lot of writing on Nabeela's chosen research question, that is whether the essential practice test is justified. And a lot of that writing, for those of you familiar with it, a lot of that writing is critical. Rajiv Dhawan and Fali Naraman, they have an important chapter on the Supreme Court's approach to religion and group life. Many chapters of Ronan Joy Sen's book are devoted to the essential practice test and again are quite critical. These and other works, they raise concerns about the essential practice test. But by looking at them closely, Nabeela, I think you can start to identify what your concerns are over and above these other concerns that have been raised by the test. And maybe when you start looking at those kinds of critical writing, you may have other disagreements with these writers on the essential practice test. Maybe you disagree with some of their criticisms, for instance. So a kind of deep dive into this literature will allow you to position yourself within the literature a little bit more clearly. Finally, once you have a really clear and a really specific thesis, it will become easier to see what arguments, as I said before, what arguments you really need to make and to support that thesis, and how to structure those arguments to best support your thesis. Because the current draft of the paper makes a number of claims. It claims, and I'm just going to go through the list of claims as I saw them in the paper. It claims that the courts should not have a checklist approach to identifying religion. It claims that Dr. Ambedkar had particular views on religion and the philosophy of religion. It claims that the Constituent Assembly took a particular view on secularism. It claims that the Supreme Court was influenced by Ambedkar's view on religion. It claims that the idea of constitutional morality might provide a better test or touchstone for identifying protected religious practices. Each of these claims is big, potentially important, and difficult to establish. And it's not always clear, at least wasn't always clear to me as a reader, how these claims are related to your overall thesis. So for the moment, I would hold off trying to establish these big claims. Instead, I would suggest once you have your specific thesis, I would think really carefully about whether you need to prove each of these claims in order to prove your thesis. Because a good rule of thumb, I think, for any paper is never prove something you don't have to prove. And I suspect that you will find that many of these broader claims that I mentioned, while they're interesting, they may not be essential to proving your thesis. That's all I had to say. I'll let Radhika take over, but I just wanted to say, Nabeela, thank you so much for sharing your work with us. I really hope that these comments have been of some use, and I really hope that you find it useful. I'm looking forward to seeing how this paper develops because I think it has a lot of promise. Thank you.
Thank you very much, Professor Ahmed. And before I invite Radhika, I just want to highlight some of the fantastic things that that Farrah has just mentioned to Nabeela, but generalizing some of them for the broader audience have today. So I think this has really been in 10 minutes. Professor Ahmed has packed sort of a masterclass in how to move from a research topic to a research question. And that is really the journey that she has outlined for you in the most crispest and clear terms. And the steps are also very clearly articulated. The first is that you have to familiarize yourself with all the secondary literature, all the primary literature, the case law on the topic. Then to figure out what is it precisely that you want to ask. If you were there, I don't know if you were there in the last workshop, Nabeela, but with Surendra's paper, our main concern was that it was trying to do too many things. Each of those things is very clever, right? But that's usually the problem with a topic, right? That there's so many moving parts. And as a young scholar, but even as an older scholar, a more experienced scholar, you're attracted to each of them. But remember what we told Surendra, one paper is one argument carefully and precisely made. So I think Farrah was, with a characteristic kindness and generosity, nudging you towards a more fine-tuned and narrowly focused question first, and then thinking about, move from a topic to a question based on the reading, and then further, more comprehensively do reading for answering that question. And everything else that's interesting to you must be left for another day. So those are really good and helpful ideas, Farrah. Thank you very much. I'm sure Nabeela found them useful, but Nabeela, before you can respond, I think I'm going to invite Radhika to give her comments first, and then I'll give you an opportunity to respond to both of them together. And then we'll take questions from the people in the audience. I should mention that because of some issues we had last time, and those who were here might have noticed, we have closed the chat room. So if you have questions for us, please email them to our Gmail ID, which is in the chat room, jffilt20@gmail.com. And one of our conveners will, if it is a legitimate question and not a harassing question, they're going to post it here, and I'll pose it to the panelists on your behalf. So this is how we will function until we find a better way to allow you to ask your own questions directly. So you can already, if the questions are popping up, you're welcome to start emailing us already. But with that, now over to you, Radhika.
Thank you, Tarun. I would firstly like to thank Nabeela for the paper. I found it very interesting and extremely relevant to the current debate on religious freedom in India. I have divided my comments into 4 sections. I will first talk about the structure of the paper, then the arguments, followed by the writing style, and then conclude with my comments on the referencing. So Nabeela, starting with the structure of the paper, I really like the logical way in which you have arranged the paper by first highlighting the problem in the introduction, then laying out the key constitutional provisions related to religious freedom in part 2, then the discussion on essential religious practices doctrine in part 3, and then the focus on constitutional morality as an alternative to essential religious practices doctrine in part 4. Here is one suggestion on which I think it can be improved further. I would highly encourage you to use signposting in the paper. So it would be helpful for the reader if you could state at the outset how you intend to develop your arguments. For example, in part 2, I will outline the key constitutional provisions related to religious freedom. In part 3, I intend to trace the evolution of the essential religious practices test and highlight the problems and so on. Next, I have some suggestions, general suggestions for improving the arguments in the paper. It is important that you engage critically with the views of other scholars. For example, in part 3 of your paper, where you have talked about Jacqueline Neo's rejection of the court's justification of the differentiation between religion and philosophy, it is also important that you state your own views on whether you agree with it or not and why. What is even more important is that you give equal importance to the views of the scholars who disagree with your arguments as much as you would to scholars who support your arguments. For instance, if there was any scholarly argument in favor of the essentiality doctrine, you would have had to take that into consideration and address it in your paper when making a case for why the essential religious practices test should be done away with. It is important to keep in mind that our role as a scholar is to think of all the possible counter arguments to our ideas and address them beforehand in our writing. Following are a few specific suggestions which I have for further developing the arguments in your paper. Firstly, the doctrine of constitutional morality itself has been criticized. Given the fact that it can be interpreted differently by different judges, it has been called a dangerous weapon in the hands of the judiciary. So how do you counter this argument? And since you've mentioned in the conclusion of your paper that the essential religious practices doctrine is problematic because it is judge-centric, and it is likely that the definition of religion can vary from judge to judge, the question that arises is, isn't this the same as the critique for the constitutional morality doctrine? Then in what way is the constitutional morality doctrine a better alternative to the essential religious practices doctrine? I would suggest here that you look at Gautam Bhatia's and Abhinav Chandrachud's responses to the criticism of constitutional morality. Secondly, since you have recommended that the constitutional morality doctrine is the way forward, the next question that arises is, what exactly do you mean by constitutional morality? And what kind of constitutional morals does a religious practice need to comply with in order to be protected under the Constitution? A good way to begin would be to first explain what constitutional morality is. In part 4 of your paper, where you have mentioned Justice Chandrachud's conception of constitutional morality, it would be worthwhile to state whether you agree or disagree with his conception and why. And compare this to Justice Indu Malhotra's dissenting opinion in the same decision, where she gives another conception of constitutional morality. So what would be your rationale for preferring one conception of constitutional morality over the other? And do you feel that there is any other way in which you can define constitutional morality? I would suggest looking at Surit Parthasarathy's article in the Oxford Human Rights Subjournal and Gautam Bhatia's article in Global Constitutionalism to develop this part further. Thirdly, it is worth looking at additional critiques of the essential religious practices doctrine. For example, how does it affect the religious freedom of communities to decide their own practices? The study of case law clearly demonstrates that initially the court was in favor of religious communities having the complete autonomy to decide the essential religious practices doctrine. And this autonomy was meant to be free from any interference from any outside authority. Can the shift in the court's view, that is in your words, judges assuming the theological attire also be criticized as infringing the freedom of religious communities to decide their religious practices? My final point regarding the arguments is that where you have made the observation in part 3 that the court is relying on Western notions, authors, and interpretations over indigenous sources to ascertain issues of religious freedom, it might be worth developing this point further as another critique of the essential religious practices doctrine. How do you think that the reliance on Western sources over indigenous ones affects the court's understanding of religious practices? A possible critique could be that given the fact that the Western literature is authored by non-native speakers of Indian languages, it might lead to legitimate doubts about the authenticity of the interpretations and the translations. Therefore, reliance on unauthentic sources can consequently lead to inaccurate determination of religious practices by the court. Therefore, you will find that there is not just one, but several ways in which it can be argued that the practice of essential religious practices doctrine is problematic. Now, in terms of the writing style, I feel that the use of simple words and the avoidance of legal jargon makes your paper really easy to read. My suggestions would just be the following. For the benefit of the reader who may not be very well versed with the Indian law on religious freedom, it would be very helpful to explain at the outset certain concepts. So, for example, while laying down the background of religious freedom provisions, that is Articles 25 and 26 in Part 2, it would be useful to mention that Article 25 protects the individual right to religious freedom, whereas Article 26 protects a group right, that is the right of religious denominations. Similarly, a brief explanation would be useful that the essential religious practices doctrine is a two-step test where first the court has to determine whether a practice is religious or not, and then the second step is to determine whether the religious practice is essential to the religion or not. Also in Part 3, where you have mentioned that in the Durga Committee and SP Mittal case, the court was trying to determine whether the petitioners form a religious denomination, it is important to note that this is the part of the religious denomination test, which is separate from the essential religious practices test. I would also suggest taking a slightly more argumentative tone in the paper. For instance, in Part 3 of your paper, where you have demonstrated how the essentiality doctrine has developed, it might be better to reorganize the information by first stating the development itself and then mention the cases that led to that development, instead of mentioning the cases and what was held in each case. Additionally, since you are making the argument that the essential religious practices test is problematic, it is important to build up the argument by critically analyzing the cases and stating how the court's understanding in these cases might be problematic. So in order to avoid over-description, a handy tip would be to keep asking yourself throughout the writing process whether what you are writing is actually helping you build up the argument that the essentiality doctrine is problematic. Lastly, with regard to referencing, I believe that the sources that you have cited, such as the treatises on constitutional law and the peer-reviewed articles, clearly demonstrate that you can discern which sources are authoritative and relevant. The only suggestion I have here is with regard to your use of certain online sources. I think that the complete details of each source should be mentioned, and also the hyperlink when it was last accessed. So those are all the suggestions from my side. I greatly enjoyed reading your paper, and I acknowledge that since this is just an early draft paper, you would work further on it, and I would be interested in seeing how you develop your arguments further. Thank you.
Thank you very much, Radhika. That was fantastic set of comments. And I should also mention that I believe this is the first time that Radhika has been a discussant for a paper in a workshop. Is that right, Radhika? Okay, so well done. You've passed with, flying colors. And I think if anybody's I mentioned earlier that, reviewing and commenting is a generous activity and a selfless activity, and, reviewers and commentators are not paid by anybody. Here is the reason why you should still volunteer to do this, because it's given human nature, it is so much easier to see some mistakes, very common academic mistakes that everybody makes, including yourself, in somebody else's work than your own. So commenting and reviewing always teaches me something that I didn't know, even when I'm, trying to help somebody else. So Radhika, that was fantastic. I'll just highlight a couple of broad points that you made and in some ways Radhika's comments chronologically come after Farah's in the writing process as well, because Farah sort of tried to help Nabeela with moving from the research topic to research questions, and Radhika's comments sort of build upon, once you have a research question, how should you move ahead with that. So the thought of signposting is really important, that you have to constantly remind the reader, this is what I'm going to tell you, this is why I'm going to tell you. Having told the reader, this is what I've told you in this section, this is why it leads to the next section. The signposting is really important. The engagement with the opposition, we have mentioned this a few times in the workshop now, but that's again hugely important, right? That you're not trying to, win votes to win your party's election. You're an academic interested in truth. So engaging with the opposition is hugely important. And Radhika has given you a lot of specific feedback, Nabeela, on how each of those arguments could be developed. But I think you should bear in mind that the paper should only seek to develop one of them, right? So often you will, people will offer you a lot of comments in the workshop, but there's also a trick in figuring out, because they don't know what it is, what line you're going to pursue. So to choosing what line you want to pursue and then taking that. So and you'll often get one of the questions I can already see in the chat box is, why haven't you dealt with X, right? It's the participant's job and the questioner's job to show all the possibilities, but it's still upon the author to not accept everything, right? The author's job is the opposite, to make the argument focused and precise and narrow. So anyway, that's a lot of background now. Thank you very much, Radhika. Nabeela, do you want to take about 5 minutes or so you don't have to respond to everything they have said, but anything that you think is important that you want to say something about, please do, and then we'll start opening the floor up. Yeah.
Thank you so much, Professor Tarun. First of all, I'll take the privilege of, congratulating the benevolent team of JFF for organizing the workshop, which is first in its time in course in India. And it's a great opportunity for young scholars like us who are actually, probably taking their baby steps into research and, looking forward to something big and something which is of a long-term commitment. So yes, this is a great opportunity, one. The second thing is I'm very grateful to both the discussants on two things which you've already highlighted. One is viewing the paper from a singular research question approach, which until now has been missing in a few things that I've been doing, for the simple reason that there's a lot of literature already available on ERP, as been told, and that's one big problem which I was facing while I was reading about ERP since 2 years. So I had two choices, and that's what I was that's what's going in my mind, either to probably go by the way of claiming a stand that this approach is definitive in its all sense and is wrong because it has a definitive approach. And this other would be from a gender perspective, which I think should be the approach that, probably I could look into owing to the interest and the work that I'm dealing with. So yes, this is one thing which I consider very relevant, and it's a relevant point made by Farrah. And Farrah also had suggested reading Booth regarding research methods. So I think I'll be taking a deep dig into the book written by Booth. So that is one thing that I came across. And the second point, and the second thing that really, let's say, thought-provoking at this point of time, she has given me one of very important comments, that there is a need to actually, probably look into the idea of homegrown literature instead of, further going into or dwelling into literature that is already present and has a perspective which cannot be assumed in the attire of a problem that is very India-centric. So first, probably, looking it from an India-centric approach, and then stretching our wings could be one approach. Yes, that's one thing I really appreciate at this point of time. And yes, taking from this, I think this will definitely help me to mold my paper into the direction that I'm trying to look up to. Thank you so much. I think that's the constructive criticism that I take from here. And I think few more drafts and few more months of committed approach to the paper would mold it in the direction that I have made up in my mind. Thank you so much.
Thank you, Nabeela. Can I just say one thing, which is that, when you're thinking about, this is mainly adding to Farah's first comment about making the question, and Radhika can testify to this, right? I think, most of the PhDs I've supervised, most of the first 6 months at least, if not the whole year, is spent in fine-tuning the question, right? Because everybody comes with a very broad question that they want to do in the PhD. And honing the question to a much narrower question is the first task of a supervisor. So even that question, is the essential practice test desirable or good, right? It's a huge question and a very big question for one paper to answer. Even narrowing it down to what can the feminist lens say about the essential practice, that's again massive. Right? So when you're fine-tuning a question, that's at least a book, if not, a lifetime's work. So, when narrowing can mean, so from your paper, for example, so take the constitutional morality section of the early paper. One way to fine-tune the question might just be, how do we understand, how should we understand the essential practices test in light of the Supreme Court's constitutional morality doctrine? And there, as Radhika pointed out, you already have two examples from Justice Chandrachud and Justice Indhu Malhotra's judgments in the Sabrimala case as a good starting point. Now notice, this is not a normative question. This is an analytic understanding question, right? Because you can't really decide good or bad until you properly understand and explain a topic, right? And I'm sure even there might be further digging happening. Possibilities. There's a whole literature on constitutional morality emerging, literature on essential practices test emerging. Another narrow question could be, how did Dr. Ambedkar understand the essential practices test or religious freedom, right? That's a historical inquiry, also descriptive, right? But still not whatever. A third question might be, how has the Supreme Court used Dr. Ambedkar's views in developing the essential? These are all paper length projects on their own, and none of them require or sort of none of them is too small for one 10,000, 12,000 word paper. Some of them may even be too big and may need further narrowing. So you don't have to bite the big sort of apple, like is the test good? Maybe that will emerge 10 years later once you have done 15 papers on different aspects of the essential practices test, right? Then you do that big job. Before I start opening up things to the floor, I wondered if Farrah, you wanted to come back with any sort of responses or comments or anything further to Nabeela?
Oh, I just wanted to kind of commend Nabeela on, I mean, we've, as you said earlier, Tarun, we've been in touch, and I'm just really impressed by her approach to feedback. So open, so kind of generous and friendly, and I just really appreciated that. So it's just a joy to talk to you about this, Nabeela.
No, indeed. Thanks, Farah. Thanks for highlighting that. And we at JFF have been extremely lucky in having 3 authors now, Mohsin, Surendra, and Nabeela, each of whom have fully appreciated the point of the workshop. So not just the discussants, they have all been fantastic, but even the authors have totally understood that the criticism is meant to be generous and constructive. It's not an attack. And thank you, Nabeela, very much for imbibing that sense of purpose that we have in starting this forum. So thank you. So let me start by addressing some of the questions, throwing some of the questions at you, Nabeela. Don't feel obliged to answer all of them. It's often fine to just say, that's a good question, I need to go back and think about it. Or I have some thoughts, they're tentative thoughts. I'm sure my ideas will develop as I think further. Or I don't know anything about it, right? And again, Farah and Radhika, you have been thinking about this topic as well, so please join the conversation. And so the first question we have is from Aditya Roy, who's a PhD candidate. And he asks, well, he frames the question, Aditya, you framed the question as, why did the paper not address? I'm going to reframe it because we know that even the best papers can't address everything. So your point, Aditya is pointing out one possibility in Nabeela's paper, which is how might the Supreme Court proceed or further develop the essential religious practices test in light of the Sabrimala review hearing, right? So he asks, if you think the Supreme Court will further dilute the test in order to keep religion sort of relatively out of bounds from the court. And notice the nature of the research question there, right? So we saw there are some historical questions you could do. This is a predictive research topic, right? Which is anticipating, looking at the trends of where the court is doing and anticipating how this case might develop in the review petition. Do you have any thoughts about this, Nabeela?
Again, I would like to thank for the wonderful question that Aditya has put up. So yes, again, I think I have to acquire the status of a soothsayer at this point of time if I were to, probably predict something. But yes, I think when we read Sabrimala in its whole essence, and we see that's what I've quoted in the last part of my paper, Justice Chandrachud's idea, and he says that the ghost of Narasu Appamai will keep on haunting us time and again. And that is one point that he brings up even in Sabrimala issue, and he quotes very openly. So yes, how ERP, since owing to its definitive character, would be molded in a way which would suit the larger sense of, public opinion formation. But then how things would turn out again is something that is beyond my scope, either of the paper and my thought that, would turn out to be. So that's one point that I'll just fairly make.
Thanks, Nabeela. And one way to think about predictive questions is this, right? So the 2 approaches, right? One, you can do a big and quantitative study to do predictions, right? Using statistics. That's not possible with this topic because the data is not big enough, right? But often with large end studies, that's possible. Another way, and this is perhaps more to Aditya than to you, given his interest in the question. One way to think about the question, Aditya, might be that, here are the possibilities. The Supreme Court has obviously issued the review in the light of the political backlash against the Sabrimala judgment. And what are the institutional options for the court, right? So it complicates the question because now we have a normative question of what the content of religious freedom is with an institutional question. What is the place of a court in enforcing religious freedom, especially when there are majoritarian concerns, right? And the legitimacy of the court may also be on balance. So it brings in a new dimension, right? So one way to deal with predictive questions like this is to, courts are difficult to predict and the Indian Supreme Court is infamously impossible to predict. You can outline possibilities.
One might be the court may double down on its existing jurisprudence. A second possibility might be that it might actually retract a bit and allow greater space for religious freedom in light of the political backlash. A third possibility might be, an even more robust and firmer doctrine in Justice Chandrachud's light, right? So you have three models. You have the Indu Malhotra model, where it's a more cautious, institutionally cautious court saying, who are we to judge religion? You have a Justice Chandrachud model, which is constitutional morality demands that we sort of, go gung-ho over this. And you have a third sort of status quoist model. We will just hold the line, no further, but no further back. Right? And even that will be intellectually very interesting to watch. But that's one way in which you might want to think about it. Radhika and Farrah, does either of you want to jump into this question? No? Okay. So there's a second question which is directed to me, but Farrah, I'll invite you to answer this as well if you want to. Do court judgments form part of literature review? How to identify literature for literature review? Farrah, did you want to address that?
Yeah, I mean, look, absolutely. I think court judgments are a part of, I don't know, sometimes we talk about literature and mean secondary literature, right? That is, by secondary literature, I mean, journal articles, book chapters, books, and so on, right? So sometimes people use literature to only mean secondary literature. But when we're thinking about literature in the sense of stuff you have to read in order to do a good job of addressing your research project, I think absolutely case law is a big part of that. So if you're thinking about exactly what your research question is, you're definitely, I think, going to have to look not just at the secondary literature, but also, and equally importantly, the primary sources, that is to say case law, legislation, constitutional text, and so on. Now, there's an interesting question, Tarun, I think it'd be useful to get your views on this as well, about what you look at first, right? Because there are definitely people who say, oh, first look at the textbook and look at the textbooks and get an overview, or look at the encyclopedia articles and get an overview of things, or look at the journal articles and get a sense of what the debates are. And there are people who say, oh, no, don't do that, because that will skew your perspective on things. So start with the case law and start with the, the statutes and don't, look at the secondary literature later on. My own view is it really depends on the question that you're asking. Because if your question is a doctrinal one, if it's a question about what is the law on this, then I personally would take the view of, no, I'm going to defer all of that secondary literature. I want to look at the case law myself, kind of unimpeded by this stuff, right? Yeah, that's what I would say.
Farrah, I could not agree more. So if I'm engaging with a doctrinal question, what is the law? How should we understand it, etc. I don't want to, sometimes even how a jurisprudence is mapped is itself an interesting research question, right? What is the Supreme Court's approach to religious freedom? And I don't want my views to be almost contaminated by how others have thought about it to begin with. So I would start with the case law and statutes. And Farrah mentioned that in passing, but I cannot emphasize enough, because as lawyers, there's almost a disease of statute blindness, right? Which is that, we just end up focusing on case law so much. So sometimes we don't stop to look at what is it that Article 25 actually says. As Radhika in one of her comments said, 26 talks about denomination, 25. So it's very important to pay close attention to constitutional provisions, statutory provisions first, to my mind, then go to the case law. And even what cases, right? One of the things that textbooks end up doing is they direct you towards what we call landmark cases, right? And who makes those cases landmark? You don't know. It's a choice that authors make, right? I think it's much better to figure out your own defensible methodological criteria. If I'm doing, so I know that Radhika, for her project, she's looking at religious freedom jurisprudence in India. She has, gone to Manupatra and looked up all the cases on Article 25 decided by the Supreme Court, all the hundreds of cases, then sifted through each of them to see which of the cases has substantively dealt with 25. Because most cases mention it in passing or whatever, and then has come up with a database of 25 cases where the Supreme Court has had a substantial engagement with Article 25. Right? If you, that must be your, that has to be your starting data set, right? Not the 5 landmark cases that everybody reads, because if you do that, there's very little hope of offering anything original, right? And you might discover that when you go to the secondary literature, you will discover how people are not looking at certain important trends or have completely ignored others. And can I just say high courts here, right? Because one of our diseases is focusing on case law in lieu of statutes. Another disease is focusing on the Supreme Court in lieu of High Court. And partly it's because of the volume that comes out of India. But a fantastic research project would just be, what have High Courts said? Or forget what have High Courts said, right? What has the Allahabad High Court said? What has the Delhi, one High Court has said on religious freedom? Right? Would be a great research paper, right? Which will add to our knowledge, and it'll be an original intervention because nobody has studied High Courts, right? We've all done the same sort of research based on the same 5-6 cases. So if it's a doctrinal research, I really think that you have to have a robust method. If you're doing Supreme Court, say why you're doing Supreme Court, why you're not looking at High Court. If you're doing sort of only 5-judge benches, you have to have a good reason for why you're not doing 2- and 3-judge benches, right? Sometimes just volume is a good enough reason, but you have to still make the case and defend it. One other thing I want to say in response to this question is, part of what you might have meant, Aditya, is what goes into the literature review section of your PhD, right? Now, when you're writing a journal article, a 10,000-word journal article, I would not recommend actually having a section called literature review, right? An article is an argument. It's not a book chapter, right? And this is linked to Radhika's comment about case summaries, right? An article should not read like a summary of case number 1 and then summary of case number 2. Here are the facts, here is what happened. Right? An article should be in your own voice about this is what my argument is. Use the case when it's relevant to your argument. At the start of your article, we've touched upon this in previous sessions, but at the start, it's very useful to locate your argument in existing literature, right? To tell the reader what it is that you're adding, right? So you say, you know, these are the existing arguments. This is group A that believes X is right. This is group B that believes X is wrong. I am going to add to this literature by showing that X is in fact wrong, but not for the reasons that group B thinks it is wrong. Right? I'll give a new reason. Or that X is right, but only if we assume or qualify it with this qualification. Right? That's a new contribution to a debate. Or that you're both wrong. That is, you know, I don't know if they can both be wrong if they're saying exactly opposite thing, but you know what I mean, right? So anyway, so I wouldn't have a section called literature review in an article. I know that PhD theses, sometimes, you know, you need to show that you have done the work, so you need to have a literature review. But again, for books and articles, you know, you're trying to explain an idea rather than prove that you have done the work. It's assumed for a publication, unlike a PhD, that you have done the work. Anything else, Farrah or Nabeela or Radhika, that you want to say?
Oh, actually, just one other thing, Tarun, like, you know, as you say, like we talk, you know, we forget a lot of doctrinal sources, right? And you're right, statutes is one of them. But I think the other thing that it's not just forgotten, but completely ignored is tribunal decisions, right? I see so little work done on what tribunals are doing. Whereas I think if you know, I'm so curious to know what all these tribunals are doing, what are they basing their decisions on, what are the you know, key factors that influence whether you win. And there's so many questions about tribunals that no one's answered. So one way you can really make a contribution is to look at some new set of sources that other people are kind of ignoring.
Thank you. Yeah, that's fantastic. And that's a very good way to narrow your project as well. Radhika, did you want to say anything?
Yes, Tarun, I wanted to add to your point where you said that the focus is so much generally on the landmark cases in the secondary literature, and that you may end up discovering a lot in the cases which are not really mentioned in the secondary literature. So because I've had the experience of writing my first chapter on how the essential religious practice test developed through cases, I found it very helpful to actually read and reread the cases, because in the first couple of readings of the cases, I wasn't able to really capture the important points. But when I went back to them and read the case the third time or the fourth time, then I ended up seeing things which did not seem very obvious to me when I read them the first couple of times. So that's the only thing that I wanted to say here.
Thank you. No, that's really helpful, and that's obviously as we learn new things, we look out for new things as well. So that's very helpful, Radhika. Thank you. Nabeela, did you want to add anything before we move on to the next question?
Nothing much. I think I'll just hear that out, and I'm making points. Thank you.
Okay. All right. So we have another question from Ravi Ahuja, who says, what, in your opinion, between constitutional right to religious freedom on the one hand and the rights or violations affected or benefited by those religious practices within those religious practices on the other hand must prevail? I'm not sure I understand this question, Ravi. Let me read the full thing. Do you believe that courts conflicting parties themselves? Okay, so Ravi, I am not sure I understand your question fully, but I'm going to give it my interpretation and pose that one. If you think I've got it wrong, please email us again. And I should also invite everybody else, if you have a question, email it to our email ID. I'll just, Jay or Swati or Animesh, if you can post the email ID again on the chat box, that'll be great. Thank you. So this is my reading of Ravi's question, Nabeela, which is that sometimes you have a conflict within a religion where there are two groups both making a religious freedom claim. So it's not a conflict between, say, anti-discrimination right and right to religion, but a conflict within the religion. So one way to think about it is the Sabrimala case, right? Where the temple, or the board or the priest on behalf of the temple, who is representing the temple, makes a religious freedom claim, claiming that their religious freedom gives them the right to exclude women between a certain age from entering the temple, right? And say at least some of the women petitioners, also part of their argument is a religious freedom argument, right? That my religious freedom demands that I should be allowed to enter a temple of my religion, right? So they're both making claims pertaining to religious freedom. How would you go about unpacking that? Or do you have any thoughts or ideas about that?
I guess I had read one of the papers which dealt with one of these issues, if I'm not wrong. So it talks about the idea of cross-fertilization, if I'm right in the sense. So it talks about the idea where you actually try to follow the literature patterns and the trajectory that has been followed in the countries where that particular religion forms to be a majority religion. So for instance, you have certain trends. Let's say in Malaysia, you have certain trends in Pakistan or some other countries, which also ironically also follow the RP test, that is the essential religious practices test. So they play heavy reliance on Supreme Court judgments, and at the other way around, we also somehow tend to look back at these ideas. So what I could infer from the question is how does one deal with when there are issues within the religion? So when there are issues within the religion and there are two conflicting ideas within the religion in itself with its own idea of manifestation propagation has set let's say step-by-step formula packages. So that is one thing that is there. And if we were to quote a lot of literature from P.B. Gajendra Gadkar, he also highlights this point that the biggest issue with the Hindu religion is that this packed formula doesn't appear to be solidified in the Hindu religion, whereas the other religions, let's say the religions that follow the book, have their packed formulas. Whenever there are issues that are conflicting in nature, come before them. For instance, there are schools of thought, let's say in Muslim religion. So the schools of thought have their own step-by-step definitive approach to deal whenever there is an issue, and this was very much prevalent in triple talaq for that matter. So these are few things, but as far as the Hindu religion is concerned, one biggest issue is that this packed formula is heavily vested with the idea how you construe and interpret the conflicting interests that comes up with. So I think there's a debate that surrounds on the set ideas and the set reliance on the tenets rather than the empirical behavior of the followers. So this is where we strike a difference, that you do not have to pay reliance on the empirical behavior of the followers rather than on the text which is given, and you play reliance on the religious text. That is the soul from which you're deriving the religion. So if that was to answer in the way, Tarun.
So that's very interesting, Nabeela. So what you're saying is that at least some religions have internal mechanisms of resolving internal conflicts, right? And it's the clearest perhaps in the Catholic Church, where there is a clear church hierarchy and an official church doctrine, perhaps somewhat less so in Islam, and perhaps even less so in Hinduism, because there is no official church and an official church hierarchy. So there's more internal diversity, arguably at least, right? Now, one way to think about this question is, what should the court do, right? So should the court, so I'm just thinking about the possibilities allowed, right? Maybe one thing for the court to do is to see whether the religion has an internal dispute resolution mechanism and just adopt that and say, okay, internally you have decided this, we'll adopt the official view. If the religion does not have that, then the court, does it decide or does it just wash its hands off? And what does it mean? Because in a lot of these cases, not deciding is also favoring one party over the other. So is the court really not taking sides? But I want to hear from Farrah on this question. Farrah, did you have any, well, I know you have views on this. Did you want to articulate any of them?
Yeah, look, thanks. I think it's a really, really interesting question, and just a really difficult one. So, I mean, I guess for me, I have to say, like, I don't think I have an answer. I don't have a very clear-cut position on it. But thinking about what are the, your question of what could the court do? What possible approaches could they take? Well, one is, as you suggested, okay, is there any sort of internal, and as Nabeela suggested, is there sort of any internal decision-making, possibility? I think the other thing that Nabeela suggested in her remarks is the court could decide which group has doctrine on their side. That is, which group is more religiously correct, right? So like, okay, you guys think this is the case, but in fact, the religion doesn't say this, right? And we know that the Indian Supreme Court is open to doing that. And again, as Nabeela suggested, another possibility is this empirical one of, well, what does the majority do? So you want to do X, but the majority does Y. So the Y group is going to win because that's the group that's in the majority, right? Now, a couple of other questions that courts have asked that I think at least some of them are useful questions, right? They think about, and Denise Rayom has a really fantastic paper on this for those of you who are interested. I cannot remember what the paper is called, but I think it has maybe hands off in the title. If someone else can remember the name of that paper, tell me, but it's a really, really good paper that deals with what courts do when there is a dispute around church property or communal property and so on, right? So one of the points that she makes is when you have these internal disputes within a religion, one question you should ask is, does anyone or any group have a claim to group autonomy? Right? Because the point that she's making is that in order to have group autonomy, the group has to be able to expel members. It has to be able to say, no, you guys are, you're the heterodox ones, you're the wrong ones, we don't want you here anymore, or we don't want you worshipping in our space, or whatever. These she thinks of as going along with group autonomy, right? So she says, look, courts in these situations have to think not just about individual freedoms, but also about group autonomy and associational freedoms. And I think that, there's a lot to her argument. Another kind of way of thinking about this that's come up in some courts is, was there something that we can think of as being like a contract? That is to say, can we think of these group of people, so it's slightly different from the group autonomy point, but can we think of these group of people, this congregation or these group of worshippers, did they come together and agree to, follow the religion in this particular way, to engage in this particular religious practice, to let, this particular priest make the decision? Because if they agreed to that, then one of the members saying, okay, excuse me, but I don't agree with like men being priests anymore, and I want to be a priest, I'm a woman and I want to be a priest. So some of those scholars would say, well, that's, it's really unfortunate that you're in that situation as the minority, but there was this kind of contract-like situation amongst the group, and you can't now renege on that contract, right? And another final set of issues that comes up is around property, right? And I think there's, obviously we can think about property and trusts in the context of Sabrimala. Also, and that seems to play a part in many of these disputes. Another really, to my mind, interesting has to do with the Western Wall in Israel, and this group called the Women of the Wall, who wanted to worship at the very similar sort of set of circumstances. The women wanted to worship at the wall, and there are people who say, well, it actually breaches my religious freedom to have you women worship in this wall. And a lot of these cases, involve physical spaces and property, so there must be some kind of legal question about, well, who has the right to that property? Who has the right to exclude other people from that property? So yeah, so as I say, I don't have an answer, but these are some of the questions that I think are actually worth asking and addressing that very difficult question.
Thank you very much, Farah. I saw a hand up. I think, was it Amber? Amber, can you email the question to the email ID? We're only taking questions emailed to us instead of asking them directly here. So a follow-up worry that Ravi raises is this, and I'm again going to rephrase the worry, which is that if we prioritize the internal mechanisms or the contractual approach that you mentioned, Farah, or sort of, this is what you agreed to. The problem with that is that it adversely affects heterodox views, minority opinions, dissenting views within the religious group. And what does that mean for the right to religious freedom, right? As in, we generally think of human rights as rights that are only really needed by minorities, by people whose rights are under threat. Right? And the dominant group within the religion does not need its rights to be protected as much as those within the religious group who are heterodox, who are dissenting, the women who want to worship at the temple, they are the minority. The women who want to worship at the wall, they are the minority. So why shouldn't the court favor them? And isn't there a deep normative problem if it does favor the dominant official orthodox view over the minority dissenting heterodox view? So any thoughts or responses to that?
You want me to go first? Nabeela, did you want to go first or should I?
Farrah, please go first because
Okay.
I have a little idea on this subject. Yes, please.
Okay. Yeah, look, I think Ravi is absolutely right. And, you know, this is precisely why for me, these are questions and it's very difficult to, at least for me at this point, to know what my ultimate position is. Yeah, absolutely. Most of these approaches, you know, whether it's what does the doctrine say, whether it's even the internal decision making proposal, the contractual, the property, the group, all of these approaches will absolutely favor the orthodox, the majority position, right? But I think in either case you're losing something. And, you know, of course, you know, it's there's a sort of instinct to favor the underdog. And Tarun, you're absolutely right to say, you know, if everything is equal, why should the court and why should the state not favor the one who is in need of more protection, right? But I suppose weighing on the other side, and as I say, I don't have a conclusion on this, weighing on the other side is the fact, at least for me, that group autonomy is valuable. It is valuable for people to be able to come together in communities. And I personally am very suspicious of potential you know, kind of backhanded ways in which the state might try to interfere with and manipulate religious groups, right? And particularly the content of religious doctrine and what religious groups do, right? So for me, those are the two things weighing on the other side: general suspicion of state interference and genuine respect for the value of group autonomy. Because, you know, and of course there's this famous but I think dated liberal communitarian debate on this, but if you're like me, then you think, look, there is actually great value in community, in communal life, and the support that people can give each other, in what we can build together that we can't build separately, and so on. And I think Riom is right. There are kind of exclusionary aspects to group autonomy. So yeah, I agree with Ravi, but there are other things weighing on the other side.
So just to add to those concerns, and this is a hard question, Ravi, and I don't know the answer to that either. Some days I think Indu Malhotra got it right, and there's some days I think Chandrachud got it right. But I think, so one way to think about the group autonomy issue is that, so to my mind, I would be a lot more sympathetic to the group autonomy argument that Farrah has just outlined if there was a genuine and reasonably freely exercisable right to group exit. So that for me is the precondition to recognizing the group autonomy argument, right? That the minorities or the dissenting groups, dissenting sections within the group should be relatively free to leave the group without serious costs to them, form their own group, right? A church with female priests or imams, and you know, a temple where women can enter, whatever, right? So that, to my mind, would certainly make the group autonomy argument more attractive. In a social context where that's not an option, I think the argument, the theoretical argument survives, but empirically may struggle, at least on a contractual basis, because there is no contract if you don't have the choice. The institutional argument, again, to add a bit more flesh to Farah's institutional argument, do we trust the state? I would go perhaps a bit further to say, not only, there's not just a question of do we trust the state, but even when the state is very sincere and does a sincere job of reforming a religion. And I think, you know, the Indian state's efforts to deal with some of the caste hierarchies in Hinduism is a good example. Even when the state intervenes in religion sort of sincerely, there can be costs to the religion that we may not want to have. And one of those costs is that the state may destroy the religion's own internal ability to reform itself, to grow. Once the state takes over a religion, arguably, or takes over the task of reforming a religion, arguably it makes a religion more reactionary, and it ends up strengthening the orthodox voices. So this is an empirical, not a theoretical claim, or empirical worry, that one of the costs we should think about when thinking about state-religion relations is not just what is the right thing to do, but who is the right agent to initiate that change, because there are costs associated with the state initiating that change. And it will be a lot better, and the change would be a lot more stable if it came from within. And we've seen those debates in the personal law context in India for a very long time, that yes, certain personal laws must become more gender equal, but those changes should not be pushed by the state, that they should come from within, right? So anyway, so I just want to put those arguments with some more fleshed out there. Radhika and Nabeela, did you want to say anything to the question of state intervention and the worry about minorities within religious groups?
I think I'll just add one point, because again, I have a little knowledge on this. The kind of petitioners and who invokes the doors of the court is also important once we look at the case law, especially when such matters are brought before the court. And that's time and again one argument. At least 5 to 10 pages are devoted in any judgment, that whether you have enough locus standi on the given situation or not. So that's one trend, probably we can have a look while viewing this. Yes, that's it.
Radhika, did you want to say anything?
Yes, Tarun, I remember that we were discussing the same issue some time back at a meeting, and I'm also still trying to think about who should be the right agency initiating any change, because my view so far is that the state has, maybe the intention is good, but it has been more of an interference in the group autonomy. And I believe that so far, my opinion is that communities should be the ones leading the change and deciding for themselves in what way they want to evolve.
Okay, that's thanks, Radhika. I just want to add one more idea, which is that maybe there is no general answer to this. It depends on what it is the minority is disagreeing about, right? So there's some internal injustices against minorities within a group that are so stark, that are so unjust, that the state, whatever the cost, needs to intervene, right? And I think that some of the practices related to caste, or some practices related to women's fundamental rights to maintenance or to support within the family, or to certain freedoms, are just so fundamental and so basic that whatever the other costs might be to group autonomy, the state must intervene. Whereas there may be, so what I'm saying is there may be a gradation of religious interests of the group, right? Where, and corresponding individual interests within the group, right? That sometimes the individual interest is so strong that it trumps the group's autonomy. At other times, so I have a lot more sympathy with claims of group autonomy when it comes to issues like how to worship and where to pray and who can pray, right? Those are things, yes, from the internal religious point of view, they are important to individual believers, but those are things I think the state should generally stay out of. But the questions that are slightly different about who can access, public paths, who can be served in a restaurant, or what are your rights on marriage and divorce, who you can marry. I think those are touching upon a different set of rights, and the state has a greater legitimacy in interfering. The other thought I want to mention is that Sabrimala is an interesting case because in most countries, the case will never reach a court at all. There is an eccentric, and this is related to our state discussion, right? a lot of these internal religious disputes, in order to reach this, the courts as a fundamental rights case, they need to show state action involved on one side, right? And in most countries, states don't run temples and churches and mosques. And states certainly don't make rules about who can enter the temple or not. Right? So India is somehow unique in that sense as well, that, you know, Sabrimala became a subject of an Article 25 challenge because the temple rules were enacted by the state of Kerala, right? And that's why it becomes a vertical dispute, because freedom of religion is not a horizontal right in most jurisdictions that private individuals can bring against each other. And we can see the chaos that might cause, right? But state becomes implicated in India a lot more in religious freedom claims because the state does so much in religious contexts, whereas a different conception of what place the state has in religion would not even lead us there. So there's a horizontality and verticality issue here as well, which again in itself is the paper at least. There's a question that Abu Nazar has raised, which is, so this is in light of our comment on reading statutes carefully. He says that the subject to clause in Article 25, which he says is missing in Article 26, is essential to our reading of the essential religious practices test. The fact that Article 25 is explicitly made subject to the other rights in Part 3 of the Constitution must have a bearing on. So this is, by the way, I should mention, Abu, that so far we've been talking about internal disputes. So when both parties are raising Article 25 claims, then the subject to clause does not matter. But Abu is right that when Article 25 is juxtaposed against other constitutional rights like Article 15, then how do we understand the subject to clause? Does it mean Article 25 always loses or not? And what does it mean for Article 26? Whether that is the stronger right in some ways than Article 25. So these are questions that you don't necessarily need to answer if you don't wish to, but I just want to mention them and invite you to give any of you an opportunity to offer any comments on the text, on this subject to clause in Article 25, and how do we make sense of that? Farrah, did you want to say anything?
Yeah, I've just opened up the Constitution. I don't know if you can you can see. Well, I have to say that's interesting. Like I hadn't really reflected on that difference before. Tell me if I'm missing something obvious, but you would kind of yeah, I can't like sort of immediately see why that would be the case, right? Why you would have subject to public order, morality, and the other provisions of this part in Article 25, and only subject to public morality, order, health, and public order, morality, and health in the other, right? It's interesting, yeah. It's just something that I personally would want to reflect on, because if I had to guess, like if this hadn't been drawn to my attention at this particular minute and you asked me, well, which one is subject to the other provisions, I would have said 26, because I would have expected 26 to be weaker than 25, right? So, and neither of those phrases seems to be by amendment, or at least that's not what is showing on my text here. So that's not an explanation. So yeah, look, that's, to my mind, just really interesting. I can't really say I have more insight than that.
It also sort of, yes, go on, Radhika.
Yeah, if I could add to what Farrah said, this was the exact issue that was being discussed in the Sabrimala temple decision of 2018, where in the dissenting opinion of Justice Indu Malhotra, she said that, we have to look at the article the way it has been written. If there is no mention of subject to other provisions of Part 3, then we cannot read into the provision something that is clearly not been mentioned. There must be some reason for excluding that phrase from the article. But the view of Justice Chandrachud was that there should be a harmonious construction of the provisions and the fact that Article 26 has not been explicitly made subject to Part 3 doesn't mean that it should not be read keeping the other provisions of Part 3 in mind. So yes, I mean, this was a very hotly debated issue in the Temple decision.
Thank you. So Amber has, it's a comment, not a question. He said that some of his concerns have been answered already, but he had similar concern about multiple interpretations of religious practices by various factions within a religious community. And how could a court take a stand regarding what constitutes essential and what is dispensable or heretic within a religion? So Amber, you know, I think we have touched upon it, but that's the big question, and I think a wise court would try to do everything to dodge it. I just don't think that is a question that any court can answer with any authority, and if anything, it's that internal dispute question is likely to backfire. By dodge it, I don't mean not decide the case, but a wise judge will find ways to not answer the religious question. Will decide it on narrower grounds, maybe sub-constitutional grounds, on administrative law grounds, and there are various ways in which, and it's very wise sometimes, you know, it's not just wise for authors to not answer all the questions there are to answer. It's sometimes very wise for judges to not answer all the questions there are to answer and to decide on narrower grounds. It's called, this idea, I think Sunstein has written on it, it's called constitutional minimalism, right? Where you, when it's a particularly divisive issue, you just decide on other grounds. Ravi has pushed back on the scope of Article 14, and it's like, you know, does Article 14 stop applying at the doors of a temple or a mosque? And I think it might be useful before we're sort of nearing the time when we should end the seminar. So maybe we'll take this as the final thought to reflect upon, which is this, to my mind. So again, I'm rephrasing you, Ravi, but I think the challenge he's posing for us is this, at least I read it as this, right? For us, the normative, the moral appeal of equality is fairly obvious, right? Why equality is desirable, why equality is good to have. But it's not often obvious beyond the fact that the constitutional text guarantees this Article 25 right to religious freedom. Why should we care about it? Isn't equality a good thing? And isn't discrimination a bad thing? So why allow something that is bad in the name of some ancient tradition run by, you know, orthodox people who don't believe in constitutional morality? So I'm putting it obviously in a provocative manner deliberately, but it's an invitation to think about what is the point of religious freedom, even when it gives some people the right to do wrong things. Why should anybody have the right to do a wrong thing? Farrah?
Well, I mean, the traditional liberal answer for me is autonomy, right? And you know, you and I have spoken at length about this, and you know that I have a problem with this. So, but you know, that idea of, well, yes, equality is important and non-discrimination is important for lots of different reasons. But if we care about personal autonomy, then we have to give people the freedom, both as individuals and as members of these groups, to, you know, to decide what kind of religious path they're going to follow and so on, right? So that's one kind of, not an explanation that I find particularly compelling, but a strong one, I think, right? And I think the other one comes to conscience, right? So Martha Nussbaum, I think, articulates this really well. This idea that, look, ultimately, and it's related to autonomy, but it's not quite that. It's, look, we have within us, all of us, this faculty of conscience, and to not allow people to live by that conscience is a huge loss to them. And so by living by that conscience, they may do all sorts of problematic things, they may make all sorts of wrong decisions, but we owe this to everybody, that to the extent possible, we allow them to live by their conscience. So to me, those are the two most powerful arguments.
Radhika? Do you want to add anything? I know that you've tried to rethink constitutional morality in Indu Malhotra's light. So maybe you want to draw upon that to say something?
Not really, Tarun. I think I don't have much thoughts on this as of now.
Yeah. Nabeela?
I don't think I can make a fair comment at this point of time.
Okay, that's fine. So Ravi, I think that's the main argument on the other side. And if you think about it, any Bill of Rights tends to guarantee two different types of rights. One set of rights directly track our interest in the good, whatever that good might be. So the right to equality or the right against discrimination is one example. Right to education is another. Right to health is another. Right? These rights directly protect our interest in something that is good. Education, health, equality, life, etc. A different set of fundamental rights track our freedom to make certain types of judgments and decisions for ourselves. And those freedoms are protected even when we choose badly, as long as we are not affecting others in a particular way. And these include right to privacy, right to freedom of speech, right to freedom of movement, right to freedom of association, right to freedom of religion. It's interesting that they're all worded as right to freedoms of something, right? And these are all rights that protect our right, in Jeremy Waldron's words, they protect our right to do wrong, right? Speech, right? There would not be a right to freedom of speech if it was only protected when you spoke rightly. But it protects a right to be mean. It protects a right to be impolite in certain contexts, right? And we worry about its boundaries, whether hate speech is the boundary where we draw the line of wrong speech. But so I think that's the way to think about religion, that there's something valuable in having that freedom. And, unlike Farrah, I'm quite attracted to the autonomy rationale for protecting freedom. I think there's something important in, you often, when not just a child, even when a friend makes a mistake, we learn from a mistake. Something important in people being allowed to make their mistakes, right? That it's, otherwise we don't grow as people and individual. And perhaps that's true of communities and groups as well. So anyway, that's at least one thought, that there is, that we should not think of all rights directly based on their substantive good, that the freedom to do something, even when we do wrong things, may be valuable in certain contexts. And that's probably why we care about privacy and speech as well. But anyway, I think this has been a very interesting discussion. I will offer one final opportunity to each of the panelists to say anything they might want to in closing. And any of you is welcome to go. Please don't feel obliged to say anything at all. But if you do want to say something, please do it now. Shall we start with Farrah?
The only thing I wanted to say was, I think one of the reasons, just going back to the internal conflict, that we were talking about, one of the factors that really adds to these debates and adds to the difficulties of the question that Nabeela is addressing in her paper is that these are the things that they're fighting over are not fungible, right? So you can't say, oh right, you can't worship at Sabrimala, or you can't worship at the Western Wall. That's okay. Go to this other wall or go to this other. It's not the same thing. So yeah, that was just one point that that I think we didn't quite get to, and so I just wanted to make that. But thank you so much. I've really had a lot of fun discussing this with you.
Radhika?
Yes, it's one comment that I'd given to Nabeela about how she can further develop part 4 on constitutional morality and how constitutional morality may be defined, because it's important to also first mention what kind of values we see constitutional morality as comprising. But I would at the same time acknowledge that it's extremely difficult to do that. I mean, I'm struggling myself with notions of whether religious freedom of groups can be said to be an important part of constitutional morality, or as Justice Chandrachud said, the notions of dignity and justice and equality, liberty are the founding values that make up constitutional morality. So I think it's very difficult because we are, when we define constitutional morality in a certain way, giving preference to certain values over the others, and we need to strongly defend our choices. So that's the only comment I have.
Thank you, Radhika. Nabeela?
Professor Tarun, I think there's one takeaway which I covertly just noted in I penned it down in my diary. That is, yeah, each judges have their own school of thought, and of course they have their own way of propagating their ideas. But then the kind of literature that they are actually corroborating their stand with is also very interesting if we were to look with. For instance, you had the Dargah Committee case where we quoted Murray's book on Sufism and the idea of Islam in the subcontinent, that is the Indian subcontinent. So it's interesting how judges approach what are the determining and corroboratory literature that they are trying to, back up their arguments with. So that in itself is again a thing that, could be looked upon when reading this subject matter. Yes.
And Nabeela, there you have a hitherto, to the best of my knowledge, unexplored topic, right? What material are Indian judges using in corroborating their opinions on religion? That is a research paper by itself, right? So that's precisely the kind of thinking you need to do, to see what it is that you'll add to our bank of knowledge on the topic, right? There's no point doing something that others have already done. So I hope this has been useful. I'm very grateful to you, Nabeela, for there is a sense of courage involved in opening yourself up. It's to this kind of public criticism, right? There's a vulnerability involved, especially when you know that the paper you are putting out is not a fully fledged finished product, but a very early stage. It's like when you're drawing something, if you can draw, that is, I can't, but if you're a painter or something, there's a sense in which you don't want to share work in progress, right? Or at least at the early stages, it doesn't look good, right? And once you develop it, you want to, with the final flourish, you sort of unveil it. So thank you very much for agreeing to do this, because I'm sure that there are many people in the same boat who want to hear how to take a topic, how to develop it into a question, and how to go ahead with that. And a huge thank you to both Farrah and Radhika, from very different points of view, one coming from a huge amount of wealth of experience in the academy as a teacher and a supervisor, and the other who is just who's just taken her first steps into academic life. But you can see the value of being a reviewer from both of these ends. And this is not at all to suggest that Farrah is at the end of her academic career, right? She's barely begun herself, but in a very short time, obviously achieved a lot. So please write to us to volunteer to be an author and to be reviewers, and we'll call upon you when we can. Especially, we're especially interested in works that are not about constitutional law, because Indian legal scholarship is just so dominated by constitutional law that it'll be good to see other material. Having said that, next month in October, we are going to have another constitutional law paper, a more developed paper by a Sri Lankan scholar, and Professor Aparna Chandra will be the discussant. So we'll advertise that again closer to time. Thank you to all our participants and for your engagement and question asking. Before I end, I want to say a huge thank you to our three conveners, Mr. Jayaprakash Meena, who's the assistant professor at Delhi University, Ms. Swati Singh Parmar, who is the assistant professor at Nabeela's University, Dharmashastra National Law University in Jabalpur, and Dr. Animesh Das, who's the assistant professor and St. Xavier's University, Kolkata, they work extremely hard behind the scenes to make this happen. So, and we will be thinking more about expanding the JFF and involving more people and making it sustainable as an institution. So, so watch the space for that. And with that, I just say thank you to all of you and see you in October. Bye-bye.